Hi, I'm Brian Schneider with MidHudson Injury Law. Today we're going to talk about something topical, especially to those in the Northeast, obviously here in New York State. Snow and ice cases and snow and ice liability. Snow and ice defects are what are known as transient defects. A transient defect is something that's impermanent. It's something that's temporary, like, say, a puddle of water or someone who spills a drink in a restaurant or a club or a bar. Snow and ice falls into that category. So in order to win, in order to prevail on the case involved in the snow and ice claim, we have to prove that the owner of the property had notice of the defect, of the problem, at some time prior to the injury victim's accident happening. There's no black and white time as to how long in advance of an accident that an owner needs to be given notice. There's no hard and fast rule saying it has to be a day, an hour, a week, or anything like that. Everything is evaluated within the context of the circumstances of the case. So a lot of what I see and have seen in my career when it comes to snow and ice cases involves instances, I should say, where people slip and fall on a sidewalk in front of, say, a restaurant or a business of some sort, or perhaps something even a little more ordinary, like just slipping and falling in a parking lot. How do you prove notice to a landowner? There's a couple different ways to accomplish it, and some of them are more realistic than others. One way is to prove that an owner had actual notice of a defect before the accident happened, which means exactly what it literally is defined as. They admit that they saw the problem sometime before the person got hurt, or someone writes something, a letter, an email, it sends it to the landowner, and through the course of, say, discovery and the pretrial efforts of the case, that letter or that email comes to the surface as evidence. I can tell you in 26 years of practice, the prospect of that happening is almost non-existent. I think I've had it happen like one time. So it's a rare day when proof of the actual notice actually comes into play in a snow and ice case. What's more likely is the prospect of proving that a landowner had constructive notice of a problem. So what is constructive notice? Well, constructive notice is essentially a set of facts or a set of events that could lead someone, say a judge or a jury, to conclude that the owner could have or should have had the opportunity or should have known of the defect through, say, reasonably diligent efforts. So, for example, think of a property manager at a shopping plaza in the days following a big snowfall here in the Hudson Valley or in New York City. That property manager is likely to dispatch their staff, whether they be employees, like, say, for maintenance or snow plowing, or just general labor guys and gals. Or maybe they call their snowplow vendor and they tell them, hey, get out there, plow, put some salt down, whatever it is. And in many instances, when you're dealing with, say, shopping plazas or shopping malls or just big retail areas, there's likely to be contracts. There's likely to be some sort of rules set by the owner, set by the owner in a contract with their vendor, their snow plower, about how frequently they need to come and plow or how much salt should be put down. There's going to usually be some guidance on that stuff. But even when all of that's done, a landowner still has the responsibility to go out and just, through their common senses and their just common sense practices, just go and take a look. What does it look like? Are there any problems that need extra attention? Is there anything that was overlooked? Is there anything that was missed, right? As someone who owns property, and it doesn't just apply to businesses, it applies to homeowners too. You got to just use common sense, and you have to take care of your property in a reasonably safe matter, right? You have to use reasonable efforts to care for your property to make sure that people who are coming to visit, and we all have those Amazon delivery guys, right? We got to, they're coming, right? You have to make sure and keep your property safe for people who are going to be traveling upon it or coming upon it. And that could include, it doesn't necessarily have to include people you actually know who are coming, like friends or family for a party or a dinner or the holidays. It could be those Amazon drivers. It could be the mailman. It could be people associated with, filling up your tanks, your oil tanks for the winter. Like, you have to take care of your property to make sure that people who travel upon it or walk upon it can be assured of some reasonably safe conditions. Naturally, there are plenty of times where those things don't happen, where property owners don't shovel, or they don't plow, or they don't put down salt. And that opens up, liability. Those injuries, those events fuel phone calls to my office and other lawyers' offices. This is the very thing. This is the very stuff that I'm trying to talk about, which can at least help you perhaps mitigate or manage any potential exposure to this. But I recognize even best efforts sometimes can fall short. So as someone who's watching this video with an eye toward maybe trying to insulate themselves, be prudent, be diligent, but you don't have to be heroic either, right? If you just use your eyes, use your ears, use your senses, you'll be able to spot some of these things fairly easily and take care of them fairly easily. So when I represent someone who gets hurt in these types of cases, I will often ask them at a deposition, or perhaps before that, ask the lawyers to produce paper showing, well, what kind of effort is invested by the owner to inspect and examine and just look over their property after these things happen. And some of these events can be, sometimes we're measuring snow in feet, not just inches. Where does it all go? Does it get piled up in a corner? And when it starts to warm up, start to melt, what happens in those situations, right? So we've talked about actual notice and constructive notice. Now there could be situations where liability can open up to a landowner for causing or creating the very defect which someone got hurt on in the first place. So that example I just said is a common one, right? People plow their snow and ice, or they pile it up in the same place. And as time goes on, there can be some thawing days or some warm-ups, or maybe it's a late season snowfall into early spring, and the snowfall's followed by a very warm day or two where there's a lot of melting, but maybe at night it refreezes, right? The recurring condition can also be something that exposes a landowner to liability. So that stuff, I think, makes a lot of sense too, right? It kind of falls into the same type of logic that I just detailed. You might be great at clearing off your driveway or your parking lot and your sidewalks. You might be thorough and diligent and timely, and you put your salt down and you put your sand down, whatever you need to do to keep the surface gritty and afford traction to pedestrians. But maybe you pile it up somewhere in a place where when that melting begins and the runoff begins, that it just kind of leads itself right back into the path where people are routinely walking, like say in a crosswalk or in a popular spot of a parking lot. You got to manage that. You have to be thoughtful as a property owner in all respects. And I know some of you might be thinking, well, geez, there's only so much you can do. Maybe you'll have so much space. Maybe there's only, there's limits to what you can do. And I recognize that. I do. But when I'm representing the accident victim, my concern is for their welfare and their well-being. And if someone breaks their leg and has hardware put into their body, and I've had plenty of those cases, quite frankly, I'm not going to be as interested or invested into what the homeowner or the property owner did. More likely I'll be focusing on what they didn't do and what they should have done. So while I can see both sides, my job and my loyalty, of course, is going to be to my clients and the injury victims themselves. So if we can prove that a landowner knew about something that recurred time and again, and they did it anyways, well, that's just going to fuel our fire. That's just going to fuel our ability, I believe, to confidently prove and succeed in proving that they are responsible for causing and creating the very defect and condition which led to my client's injuries. So that's how we want to try and attack the notice element. But we can kind of step back and speak more broadly or generally about some other like circumstances or situations that come up a lot in these snow and ice cases. A common one is the slip and fall on a sidewalk in the days following a big event, a big snow or ice event, and someone gets really, really hurt. Now, public sidewalk claims are hard. You're not most likely going to succeed in suing a city or a town or a village under those circumstances. So if you called me and you're looking for help, like what could we do? I've had cases where, depending upon exactly the location, like which town or city this happened in, you can look to city or town codes. And there is usually language, not necessarily in every instance, but in many instances, there's language in city and town codes that actually shifts the liability of snow and ice removal from public sidewalks to the abutting or adjacent landowner. So in plain English, if you own a home or business and a public sidewalk runs in front of it, the likelihood is that you have to keep it clear. And that's not just because you're a good person or a good Samaritan, that there's likely to be a code, in the city charter or the town charter that actually mandates that be done. So you can, be found liable under the right circumstances, of course, for not properly clearing a public sidewalk that kind of borders or is adjacent to your property. And that applies to private, single family homeowners as well. Okay. There's going to be language, and I've seen it in many instances, about the timing that you're afforded as a homeowner to clear your adjacent sidewalk of snow and ice. I've seen sometimes it says you have to clear within 12 hours after the cessation of the storm. And of course, you have to use reasonably diligent efforts. And that can be helpful if we can prove that maybe that wasn't done, that we, of course, the plaintiff's lawyer or the injury victim's lawyer, can prove successfully that wasn't done. So again, just because it's a public sidewalk, adjacent landowners, homeowners, business owners shouldn't be complacent. They should get out there and they should do it. And I know people watching this have probably had a variety of personal experiences just walking on these sidewalks. It happens to me too. I'll be walking through a village or a town after, days or even a couple of weeks after a snow or ice event. And you'll still encounter, really, lousy shoveling jobs, or just, very, very poorly done or half-hearted efforts put into clearing snow and ice. That's exposing those owners, those adjacent owners, to potential claims and lawsuits. Just a couple other things I want to point out. I'd mentioned this turn of phrase, the cessation of the storm. That's actually something that comes up a lot in these snow and ice cases. People who might slip and fall at a location in the middle of a storm. Does that expose or automatically open up liability to a property owner or a homeowner? No. The law does build in some measure of forgiveness, if you will, to property and landowners. They're not expected to be robotic and go out there constantly 24/7 during a snowstorm or a blizzard to make sure that their parking lot or their sidewalks are perfectly clear and free. That's impossible, right? So there are exceptions, which I don't need to delve into for the purposes of this video today. But the general rule is that landowners are given, some measure of time after the end of an event, after the end of a blizzard, the end of a snowstorm, to go out and actually clear their parking lot, clear their sidewalks of snow and ice. And it's a logical application, right? It's just, again, common sense. You're not going to likely have the success of keeping things perfectly clear of snow and ice in the middle of a blizzard. So whether it be a blizzard or something a little more low key, there are often times where the timing or the ending of a storm can factor into whether or not a homeowner or a property owner acted reasonably in taking care of their property after the fact. There are other elements that naturally come up with these types of cases involving, for example, weather experts or meteorology experts getting certified weather records. I've had the good fortune of teaming up with some very sharp and sophisticated weather experts to help prove cases and succeed for my clients. That can kind of take us down a different road and discussion for another day. But I just want to conclude by saying, when it comes to snow and ice cases, proving that the landowner or the homeowner had notice of the problem in some time sufficient prior to the accident is the key to prevailing in a case.